Hello, I'm Howard Nations of the Nations Law Firm in Houston. Welcome to our podcast on Introduction to the Camp Lejeune Justice Act of 2022. The Nations Law Firm represents thousands of veterans, and we've represented them in the past and in the present on, for example, we have cases in Washington, D.C., federal court against the country of Iran for their terrorist activities that wounded these warriors. We also represent the wounded warriors in New York suing the banks that are laundering money in order to buy weapons of war to use against our troops. They're laundering money for the terrorist organizations. For the past 2 years, we've worked directly with Ed Bell, who is the godfather, the scrivener, the writer, and the driving force behind the Camp Lejeune Justice Act of 2022. Ed called me and asked me if I'd like to work with him and help him push this thing through Congress. I was thrilled to do so. The first time I read the Camp Lejeune Justice Act, as Ed had written it, I said, "Boy, that'd be great to get through this, but we'll see how much of it we can get." Well, the fact is, we got it all. So during this time, for the last 2 years, I've been doing a deep dive on the law, the medicine, the science, and the toxins to prepare for the day that President Joseph Biden signs the bill into law, which is August 10th, 2022. We'll be doing a series of podcasts as the litigation progresses, and we'll be making regular additions to our veterans website, which is also for use by lawyers. It's justiceforveterans.info, justiceforveterans.info. If you need help on a case, call me. We're also accepting referrals and joint venturing cases with several law firms. We can be reached at nations@howardnations.com or on the justiceforveterans.info. I'm very happy to say that joining me on these webcasts will be David Wenner of Snyder and Wenner in Phoenix, Arizona. David is an excellent trial lawyer, but David brings a lot more than trial skills to the trial of a case and to the handling of litigation. David is also a PhD in psychology, and he has devoted his life to studying the decision-making process, jury bias, and all of the aspects of forensic psychology that pertain to the art of persuasion. David headed up the AAJ, or ATLA back then, the ATLA study by conducting several focus groups on the issue of overcoming jury bias back in the 90s. David and I then traveled all over the country giving speeches on the subject of overcoming jury bias, but that was purely his work product, and he did a great job with it. And I'm glad to say that Dave's working with us on these Camp Lejeune cases also. David and I plan to do a series of podcasts on Camp Lejeune as we progress through the litigation, but we're also going to cover such matters as overcoming jury bias, trial skills, use of focus groups, and many other trial-related topics. David works as a trial lawyer, but he also is an excellent trial consultant. I wouldn't think of going to court without him. In that role, he conducts hundreds of focus groups each year, and he's excellent at it. We will begin focus groups next week in North Carolina, testing various aspects of the Camp Lejeune Justice Act of 2022. And we'll post the results on a regular basis and talk about them in podcast. And our next podcast, though, will be devoted to navigating the administrative claim in a Camp Lejeune case. So now let me introduce you to David, and then we'll talk about the overview of the Camp Lejeune Justice Act of 2022.
Howard, good afternoon.
Good afternoon to you, sir.
Today, we're going to talk about the Camp Lejeune Justice Act. And would you, if you please, tell us what the act is?
Okay, but before I tell you what the act is, David, let me try to clear up a lot of confusion out there. Let me tell you what the act is not. This act is definitely not a Federal Tort Claims Act, even though we're suing the federal government on behalf of military. It's not a Federal Tort Claims Act. It's also not an MDL, despite the fact that there could be as many as 200,000 people involved in it. It's not a class action. It's not a mass tort as such, because each case has to be prosecuted in two fashions. Number one, it has to be prosecuted as an administrative claim under Title 28, Section 2675, which is the same way basically that you prosecute a Federal Tort Claims Act. But you have to have that administrative claim action when you sue the government. So after you get through that, then it's prosecuted as an individual lawsuit in the Federal District Court for the Eastern District of North Carolina, and you have a right to trial by jury. So what it is an individual case with exclusive jurisdiction in the Federal District Court for the Eastern District of North Carolina.
And so, unlike a federal torts claim case, the plaintiffs will get the right to a jury trial in federal court.
Right.
So now tell us what it is. You've told us what it's not. I know there's a lot of misconceptions about what it is out there. So tell us what it is.
Okay. The Camp Lejeune Justice Act of 2022 is actually found in the PACT Act. You'll hear a lot of publicity about President Biden signing the PACT Act. Well, that is our act. That's the Camp Lejeune Justice Act. Because Camp Lejeune Justice Act was incorporated into the PACT Act, which is a very large veterans benefit bill, and it's Section 804 of the PACT Act. But the short title for this section, for 804, is the Camp Lejeune Justice Act of 2022.
And so the PACT Act is the one. There was a lot of publicity with Jon Stewart on TV, and they were talking about the burn pits in right. Iraq and Afghanistan. And the Camp Lejeune Justice Act is incorporated into the PACT Act.
Right. It was. Okay. This was submitted originally as the Camp Lejeune Justice Act of 2021. Then in early 22, it passed the House of Representatives. Then when it got to the Senate, the senators who were helping on this, Tester and Blumenthal, we've had great help on this, said you'll have a much better chance of getting the attention that it takes to get this bill passed if you will incorporate it into the PACT Act, which is also a veterans benefit bill. And that was the best advice anybody ever got on legislation, because it was when it went through as Section 804 of the Camp Lejeune Justice when it went through as Section 804 of the PACT Act, it didn't attract a lot of attention that it would have attracted had it been submitted as a standalone bill.
And in this day and age, you don't see too much bipartisan support for the same legislation. But in this case, what happened?
Well, in this case, we had bipartisan support in the House of Representatives. Nancy Pelosi was a big supporter of this bill, and it did pass there as a standalone bill. And then when it got to the Senate, we had absolute bipartisan support. We had the co-sponsors. They had 18 co-sponsors. The co-chairs were one Republican, one Democrat, and then they said, no, we want this thing. So every time you add a sponsor that's a Democrat, you're going to have to add a sponsor that's a Republican, because we want to keep this bipartisan. So when it finally went to a vote on the floor, it was passed at, you had you had a total of 18, so you had 9 Republicans, 9 Democrats in the 2 chairs co-sponsoring it. So we passed it there at 84-14 through the Senate. Then it went back to the House, had a technicality, had to pass it again, then came back to the Senate, got a little wrinkle in it because of the PACT Act, not because of the Justice Act. It had to be passed again, and the second time it was passed, the vote was 86-11. So this is true bipartisan legislation.
Pretty credible in this day and age. Well, let's start talking a little bit about the act so people get a feel for what it is. Who can bring a claim under the act?
You know, that's a much better question than you might think, because I've seen a lot of misinformation about this, and it's so simple. All you have to do is read the first paragraph. The people who can bring an act, it doesn't say a soldier, a Marine, a military. What it says is an individual, including a veteran, can bring an act who, if they resided, worked, or otherwise was exposed, including in utero exposure, for not less than 30 days during the period beginning August 1st of 53 and ending in December 31st of 87, if they were exposed to the water at Camp Lejeune that was supplied by or on behalf of the United States. So it's individuals, it's civilians who work on base, it's contractors, a lot of contractors working out there, civilian contractors. It's the family members of the Marines, a lot of people in the family units where both the Marine and the spouse and the children were exposed, and we've had cases where 5 or 6 people in one family have adverse results from this. So it's a broad decision. Now, not only that, there are people in housing that is contiguous to the flow of the water at Camp Lejeune, and they also got exposed. And if they had 30 days on the on Lejeune during that time frame, civilians in resident neighborhoods also have claims. And on this 30 days, the 30 days does not have to be continuous. You can have 3 days here, 3 days there. You just have to have a total of 30 days in that 34-year period.
You know, we've been talking about Camp Lejeune, and a lot of people who have not been in the military, like myself, I know you have been in the military, but where is Camp Lejeune, and what kind of base is it?
Camp Lejeune is a very substantial, huge base for the Marine Corps. It was built in '41 in anticipation of World War II, and they wanted a place where they could do a lot of landing. They were getting ready for landing troops, so they wanted a place on the coastline. So they went to North Carolina, and they found this forest in North Carolina, right outside the small town of Jacksonville. It's on the coast because there are 14 miles of beaches where they can do all sorts of landing operations, and it's now grown to be just huge. But it's in North Carolina, and it's the base where people go to Parris Island generally for their basic training, and then Camp Lejeune is where you go for advanced training, and people come there all the time for additional training. Units come there for training. Units come there waiting to be deployed around the world, and people generally live there for 2 years at a time when they're assigned, and the average age there is 25 years old between the Marines and their children on base. So the average age is 25, and it's a big operation.
So you said it's a Marine base, am I right?
Yes, it's the United States Marine Corps.
Now you talked about these 30 days, this 30-day period, but what time period generally are we talking about? What are the dates, inclusive dates of when the exposure took place to qualify as a plaintiff?
Well, the exposure date that they landed on finally starts with August 1st of 1953, and this was after the base had been open since 41, and when it opened, it started with Hadnot Point was the first residential area, and they started getting into some problems with Hadnot Point pretty early in the game, and then it ran for 34 years until December 31st, 1987. And during that entire time frame, that entire 34 years, there's just study after study after study, and you'd see the same pattern. There would be, hey, there's a problem with the water. The water looks dirty, something giving it away. There's a problem with the water. Okay, there's a study. There's results from the study, and there's a recommendation from the study, and then the next thing you see is no further action. And that's a pattern. That's a pattern for 34 years. So the military was pretty unconscionable in the way they handled this.
And so we're talking from August 1st, 1953 to December 31st, 1987. That's the inclusive period for which these claims arise.
That's the time frame during which you had to have had 30 days of exposure in order to qualify as a claimant in this case.
Now, you had said something about the jurisdiction, and as I understand it, there's a provision in the Act about exclusive jurisdiction and venue. Would you tell us about that?
Yes. The exclusive jurisdiction in this case is in the United States District Court for the Eastern District of North Carolina, and the exclusive venue is also at the United States District Court for the Eastern District of North Carolina. Now, there are six federal judges in the Eastern District of North Carolina and 6 magistrates. So they are the thing that complicates this thing, but complicates it favorably for the plaintiffs, is that the Act maintains the right to trial by jury. So a lot of larger consolidated cases that you get into are judge only. For example, I have litigation in D.C. court on behalf of about 2,500 wounded warriors and their families, and those are non-jury trials. This is jury trial, so that adds a lot of rights, but it also adds a lot of complications on handling the case.
And a lot of work.
Yeah.
Now let's talk about what it means to be the exclusive remedy. The Act addresses that. This is the exclusive remedy, and what does that mean for the claimant?
Well, the most important part of the exclusive remedy is that this is not a Tort Claims Act case. You cannot prosecute this same claim under a Tort Claims Act case, and with this being the exclusive remedy, it's to separate this from the Ferez Doctrine and from the limitations and immunities of the Federal Tort Claims Act. But the effect of that is that if you prosecute a case under this Act, then you cannot later bring a tort action against the United States under any other law besides this one.
So now's the time to do it if plaintiff's going to bring.
Yep, it's 2-year period. Yes,
2-year period, and so well, we're going to get to the statute of limitations in a bit, but there are also subrogation rights that are included in this bill. What is that?
Now let me explain this, because there's a lot of confusion about this. You have subrogation rights on behalf of Medicare, Medicaid, and the VA, and under the Social Security Act, it's the Medicaid, but people stop reading there. The rest of the Act says if you had a loss, if they paid out health care or paid out disability for a loss relating to exposure to the water at Camp Lejeune. And I've heard people say in speeches that remember that the Veterans Administration has a lien on everything they've paid this veteran. So you have to deduct that from the award. That's absolutely wrong. The only lien they have, and they have the burden of proving this, they have a lien for any health care or any disability that they gave pursuant to exposure to the water at Camp Lejeune. And for the most part, these were denied. These injuries were denied. So if they have a claim, a subrogation interest, it's not going to be, it's most, as a general proposition, it will not be that large. And even at then, it's going to be negotiable. So subrogation rights is not that big a deal.
So for instance, if somebody is making a claim under the Act that the water contamination caused some type of cancer that the VA has been treating them for, is that something that they could potentially claim rights to subrogation for the?
Yes, the VA could come in and claim that the value of their services were at services for treating the cancer that arose from this, but the VA for the most part wasn't treating these cancers.
I see.
So it's not going to be that big a deal.
Okay, so there are immunity limitations that were built into this bill or incorporated into this bill. Can you talk to us about that?
The immunity limitation is for one simple reason. It's to very clearly eliminate all of the immunities that the United States government has enjoyed all of these years, and those immunities are why they've never paid anything under the Federal Tort Claims Act on these cases, because they had multiple immunities. This one just says they may not assert any claim to immunity in this act that would otherwise be available under 2680 of Title 28.
That's incredible, because in the past
basically eliminated the defenses.
Right, and so in the past, somebody in the military couldn't sue the federal government for negligence under the Ferris Doctrine or anything else under the Ferris Doctrine, and you're really out of luck. You were their captive if you were injured negligently or recklessly or some other way. There was no claim to be made because the United States was immune from any litigation rising out of the injuries. Okay. Right. Wow, that's truly.
Those are gone. Those are eliminated.
Truly incredible.
Makes it so much cleaner.
Yeah, it always makes it cleaner when you've eliminated the defenses. That's true.
Yeah.
Or any immunity. So also, I mean, you would think that these chemicals were being put in the water all these years, and it was, what did the government know and when did they know it? And probably a lot, but the Act does address the issue of punitive damages, and so tell us about that.
Yeah, the conduct absolutely qualifies for punitive damages, but you can't get punitive damages against the government, and so they concede that point. So the Act itself provides that despite the egregious conduct of the government, there are no punitive damages in this case, which might be better, because if you're going to have some evidence about the bad conduct, but on the other hand, if you had punitive damages, federal courts have a tendency to reduce them considerably, down to usually a 9-to-1 with the compensatory damages. And if you don't have punitive damages and the jury is not asked to award punitive damages, they can hear some evidence about the egregious conduct, and then they can put the damages into the compensatory damages. And the judges do not have a tendency to reduce compensatory damages because that's clearly in the province of the jury. So I think we're actually better off having compensatory damages, and not having punitive damages.
We're going to run some focus groups on this, but we know that there is punitive conduct here. Well, you can't get punitive damages. What you're saying is that the bad conduct, the punitive conduct, is going to drive the actual compensatory damage because there was a huge betrayal here.
It may, but there's one other wrinkle in this, and that is they may decide to admit liability to keep all the punitive conduct out. But then you still would have the opportunity to prove the case-specific conduct. For example, if you had someone at Had Not Point, which is one of the residential areas, and in Had Not Point, you could show that wells were dug that were much too shallow and they were on a downhill slope, and it was negligent conduct, and they were there was so many contaminants there. You could show that this person has a cancer that's caused by TCE, and then you could show the source of TCE right there in Had Not Point. You might be able to get some things in case specific like that, but just the overall picture of how horrible this conduct was, we're gonna have a hard time proving all of that because they're just simply not going to let us prove it. I wouldn't think. I hope they would, but I don't think they will.
Sure. Well, one of the things that you had mentioned earlier was this administrative claim, and as every plaintiff's lawyer in the country knows, that if you're going to sue a governmental entity, state, federal, local, you have to make a notice of claim, and this act as a provision for that. It's no exception. There needs to be an administrative claim filed. So can you address that for us?
Sure. There's a very, very important distinction here. This act adopts Section 2675 of Title 28, which says that you should have a disposition by a federal agency is required. And it says the 2675 says that an individual may not bring an action under this section before complying with 2675. Now, what it doesn't say, it adopts this as part of the Camp Lejeune Justice Act. But what it doesn't say is it's not adopting 2680. 2680 is the part that puts a limit on the damage, on the attorney's fees recovery for attorneys both at the administrative level and at the trial level. So 2680 says that if you settle a case at the administrative process, that you're capped at 20% attorney's fee. And if you settle a case at the trial process, you're capped at 25% attorney's fee. The 2680 is not part of the Camp Lejeune Justice Act. And that's why it's important that the Camp Lejeune Justice Act is an exclusive remedy. So they can't reach over here and say, okay, we're gonna follow the Camp Lejeune Justice Act, but we're gonna reach over here to the Federal Tort Claims Act, and we're gonna pull Section 2680 in here, and we're gonna limit your attorney's fees. They can't do that because the Justice Act is an exclusive remedy, and it adopts only 2675.
So, I mean, that's important. I mean, in any Federal Torts Claim Act, the fees are limited during the litigation to 25% of the recovery. And this act does not incorporate that same provision that is contained in the Federal Torts Claim Act. Am I right about that?
Yeah.
And so, but the other thing you said was important. Before you can file a claim, you must file a notice of claim with the appropriate federal agency, and the appropriate federal agency is what, the Department of Navy?
Well, in this case, it's the Navy JAG. And Navy JAG is handling the administrative procedures. I've talked to the man who's heading that operation at Navy JAG, and they're looking at 100,000 claims at least in the first year, and in a 2-year period they could be looking at anything from 150 to 200,000 claims. And Navy JAG, they're not really JAG officers because they've contracted out their tort claims. So you have civilian lawyers who are employees of the Navy JAG department. So you have, in this particular Navy JAG office where this is being handled, you have 10 civilian officers, 10 civilian lawyers who have to do all the work, and then you have two executives over them. But the fact of the matter is, the practical matter, it's going to take them all of their time just to administer all the claims that come through there. And so the fact of the matter is, I don't think we can expect them to be taking time to evaluate claims and try to negotiate claims. I don't think we're going to find much negotiation or much attempt at that, just from the sheer weight of the trying to administer 100,000 claims.
Sure.
I think we're not going to find any opportunity for them to sit down and say, okay, let's evaluate your 10,000 claims. It's not going to happen.
Well, I know we're going to talk in the later podcast about more in detail about the notice of claim, the administrative claim. But let's turn to the statute of limitations. And I know the Act contains a provision on statute of limitations, and there's a strict statute of limitations. So tell us about that.
Okay, so you have statute of limitations is combines the administrative claim with the normal statute. The statute of limitations is 2 years after the date of enactment of this act. Enactment means the day that it is signed into law by the President of the United States, which should be, it is scheduled to be signed into law on August 10th, 2022.
That's tomorrow.
That should be. There's going to be a signing in the Rose Garden tomorrow. And so that should be the starting date. So the statute will be 2 years from August 10th, 2022, or, and this is where the administrative part comes in, or the date that is 180 days after the date on which the claim is denied under 2675. So you file your claim with under 2675. You have to do that first. You file that, and then whatever period of time, they have 180 days to handle your claim. And the 180 days, at the end of the 180 days, if they don't deny it, if they don't rule on it, they don't deny it by that time, it's deemed to be denied. And so after that 180 days, when you get a deemed denial, then you're free to go to court and file your lawsuit in North Carolina.
You want to talk just briefly about statute of repose that may exist under North Carolina law?
Yeah, the statute of repose is important because they tried to do this in 2010, and in 2010 they tried to form it as an MDL, and they got started and everything was running fine until they ran into the statute of repose in North Carolina. North Carolina has a 10-year statute of repose that does not have a latency period provision in it that extends the statute. So those cases were dismissed under the North Carolina statute of repose. So now, under this provision, it says any applicable statute of repose or statute of limitations other than the one we just went over shall not apply to a claim under this section. So, in other words, there's no statute of repose, and the only statute of limitations is the 2 years, 180 days that we just talked about.
There may be non-lawyers watching this, and there probably will be. So, could you explain to us just briefly what a statute of repose is? It's sounds like a lot of legal technical language, and if you just would tell the public who aren't lawyers, what that is. and how that would apply in this instance, and why that it doesn't apply in this case is a good thing.
Well, the statute of repose, every state has one, and they say that after a certain amount of time, you cannot bring a lawsuit. For example, it might be in a product liability case, a defective product. A statute of repose might say we have a 20-year statute of repose in this state, so it doesn't matter when the injury occurs. If it's beyond the 20 years, you can't sue this. You can't sue this defendant.
So
and so it's after a certain amount of time, whatever that is, 10, 15, 20 years, whatever the state adopts, that lawsuit just can no longer be brought. Now, a lot of the statutes of repose will say if you have a situation where you are suing for something like a cancer, a mesothelioma, or something like that has a long latency period before you discover it. So let's say the statute of repose is 15 years, but you didn't discover you were injured until 20 years. They have a latency period that extends that statute of repose. North Carolina doesn't have that, which is why this case was wiped out in the first place in 2010.
Okay. All right. So we've been talking a lot about toxic chemicals and people being exposed to these poisons. Why don't you tell us, number one, first, what toxic chemicals were placed into the groundwater, into the well water, if you will, around Camp Lejeune, and how did it get in there?
I saw one place where they indicated that in the studies that 71 different toxins of various types were found in the studies. And if you took all the studies at Camp Lejeune, they found 71 different toxins. However, there's no question that there are 4 that are the primary cause of the problems. The first is benzene. The second is TCE. The third is PCE. And the fourth is vinyl chloride. Each of these is a known carcinogenic, and they are all over the place. And then there were some other examples, though, aside from just those 4. This kind of shows you, to some extent, how sloppy they were. There's a dry cleaners, an ABC Cleaners, which served the base. It was just across the street from the base, and they were dumping TCE. TCE is the dry cleaning fluid, and they were dumping TCE for 34 years, and they were some is liquid and others a mass. They'd take the mass and leave it in the backyard, and just it'd seep into the ground. And the liquid was also seeping into the ground, and this was just across the street from Tarawa Terrace, which is one of the primary residential areas, family residential areas. And when they built water wells, when they put water wells in and storage tanks in, they built them right across the street from this cleaners, and they built them very shallow, and they built them on a slope so that the toxins from the cleaners were coming across, and then they were sloping downhill. They were just flowing right working their way right into the water supplies, right into the wells. So there's a whole long line of wells along there. And then another instance, they had 30,000 gallons of fuel that leaked in a place called Hadnot Point, which is the original, right in the middle of the residential area. And this was the Hadnot Point, it's called the fuel farm, and they lost 30,000 gallons of fuel, just leaked into the residential area, into the residential water. They also found in Hadnot Point, they found 499 radioactive beta buttons were discovered just routinely when they're just caring for the place. And beta buttons, radioactive beta buttons, are strontium-90, and that's just tremendously carcinogenic. And then on the rifle range, they had the gas drums. They found gas drums that were buried. They were just doing some work out there, and they discovered, they dug up accidentally. They dug up these barrels, and they looked pretty dangerous. So they brought over the hazmat people, and they found that they were buried just below the ground. So I mean, just barely below the ground, and that was nerve gas, if you can imagine. And then they had another one where they had DDT buried in a pit. And these are all in training areas, right there in the training areas. They were dumping ammunition. They were always dumping ammunition, and they were always dumping fuel. And fuel was one of the big causes in this thing. They just dump fuel and leave it there. And then, of course, you heard about the burn pits in Iraq and all that sort of thing. So they're just carcinogenics everywhere.
These chemicals were seeping into the well water, and people were then drinking it, bathing in it, eating the food that contained water, and over all those years.
Yep.
Okay. Boy, what a betrayal! Unbelievable. So let's talk about this. I got to tell you, as a lawyer, this act contains some really interesting burdens of proof, and
to say the least.
Yeah, I think we should talk about that. Tell us a little bit about that.
Okay. Well, the burden of proof in this case is, to say the least, unique. So you need to look at it carefully, I mean very carefully, to see exactly what it says. But the burden of proof is on the party filing the action. But the act says to show one or more. That's so significant. The burden of proof is to show one or more relationships between the water at Camp Lejeune and the harm. One relationship between the water and the harm. To meet the burden of proof, a party shall produce evidence showing that the relationship between the exposure to the water and the harm is sufficient to conclude that a causal relationship exists. So obviously you have to prove causation. Or sufficient to conclude that a causal relationship is at least as likely as not. Now listen to that. We're used to more like it's more likely than not, 51% rule, what all sorts, but more likely than not is the standard we follow routinely. But this has a second section in it which says it's sufficient to conclude that a causal relationship is at least as likely as not between the water and the harm. And so this has been done for us on with several different
let's stop
cancers and everything.
And sort of savor that.
You want to,
because
you want to stop and enjoy that for a moment?
The burden of proof we have to prove that by the greater weight of the evidence that our version of the facts is correct, and to a reasonable degree of probability, 51% more likely than not. But in this case, the act has lowered that requirement to as likely as not, which
Right.
50%, right? Am I
Right.
unbelievable? Yeah. And fortunately, the government has done a lot of the work for these claims, and let's turn to that. And the Agency for Toxic Substances and Disease Registry, the Department of Health and Human Services. Tell us about what the government has done in that regard.
Well, the ATSDR is a federal agency which is under Health and Human Services, then it's under the CDC, then it's the ATSDR, the Agency for Toxic Substances and Disease Registry. They pull together everybody else's studies, they do their own studies, and they classify the evidence on toxicity and so forth. Now, Sufficient, when they regard, they'll look at a cancer like kidney cancer, for example, and they'll say, okay, we've looked at the studies and we find that the evidence is sufficient to conclude that a causal relationship exists between the water at Camp Lejeune and the development of this kidney cancer in this patient. Sufficient is the highest standard. It's more likely than not. But then there's this term called equipoise, and equipoise is the real key to an awful lot of recoveries here that you wouldn't get if it were strictly more likely than not. Equipoise is an epidemiological term, which means as likely as not. So the classification of evidence, number one, is sufficient. Number two is equipoise and above. And equipoise is that the evidence is sufficient to conclude that a causal relationship is at least as likely as not, but not sufficient to conclude that a causal relationship exists. But so it doesn't make the more likely than not, but you only have to make as likely as not, because that's the burden of proof. So that, and then below equipoise is they've done studies. The evidence is not sufficient to conclude that a causal relationship is as likely as not, or is not sufficient. Now, that doesn't mean, we'll get back to that, that doesn't mean those cases can't be won. That just means that you don't get presumptive causation, which I'll talk about in a moment. And then you get finding against, and then the against finding means that they've concluded that it's, the evidence suggests that there's a lack of a causal relationship, which is stronger.
So let's talk about I know there's other federal agencies have done, they've classified this evidence. What were they?
This has been studied, this problem has been so well known since the 50s, and it was there for 34 years. It was studied by the IARC, International Agency for Research on Cancer. It's studied by the EPA. And it was finally determined by the EPA as a Superfund site in '87, and so was the cleaner. The ABC Cleaners was determined independently to be a Superfund site. And then there's a National Toxicology Program. There's the Institute of Medicine, who studied this, and then the CERCLA, which is the Comprehensive Environmental Response, Compensation, and Liability Act. That's the Superfund Act. And Camp Lejeune qualified for CERCLA, the Superfund, and so did ABC Cleaners. And then there's the National Priorities List, the NPL. So when they put you on the National Priorities List, it means you're a bad actor. And Camp Lejeune is on it.
And now, point out the Institute of Medicine is part of the National Academy of Science, and is probably the most prestigious medical organization in America. So if they put their imprimatur or stamp of approval on, then there's a lot of power behind that. So okay, go ahead. We're going to add something, Howard?
No, that's. I was just going to tell you about the real key that makes this thing so different than other burden of proof is equipoise. So let me tell you about equipoise and above. These are there are 10 cancers which have been determined by the ATSDR, a government agency, to be equipoise and above. These 10 cancers, in other words, they have done studies. For example, kidney cancer. Kidney cancer, they've determined is caused by TCE. There was a study by Welsh in 2010, the EPA in 2011, and Karami in 2012. At the National Cancer Institute. So there's 3 different studies that studied kidney cancer, and they all decided that the evidence was sufficient. Now, the evidence is sufficient to show to presume that the exposure to the water caused the harm, caused the kidney cancer. Now, as a result of that, we can go to the court and ask the court to take judicial notice that the United States government has found, ATSDR, has found sufficient evidence of a connection, the causal connection between the water and the harm, that we should be entitled to presumptive causation, that we should get a presumption that this causation occurred because it's scientifically proven and established by the federal government. We're suing the federal government says, hey, this is sufficient, then we should get presumptive causation. So that's what presumptive causation is. It's a rebuttable presumption, of course, but it's strong going in. So you have kidney cancer, non-Hodgkin lymphoma, you have multiple myeloma, leukemia, liver cancer, bladder cancer, and then you get systemic sclerosis or scleroderma, and then you have Parkinson's disease, kidney disease, and then major cardiac birth defects. Those are the 10 that are just chosen by ATSDR, and we clearly get presumptive causation on those. And so you come in and prove that you prove the water, you prove the exposure to the water, you prove the 30-day exposure, that you were there for 30 days, and then you ask the court to take judicial notice of the fact that you made causation between the water and the kidney cancer, and then the burden shifts over to the government to prove no, there's not a cause. That's not the causation. There are all these other possible causations, but that's going to be tough. Now, let me tell you about the insufficient medical studies.
I just want to point out that you
go ahead.
Earlier, Howard, that the act contemplated injuries in utero injuries.
Yes.
And that is these major cardiac birth defects there's an established link between TCE and those things. And so women who are, family members living near the base or on the base who were pregnant at the time, the babies were born with cardiac defects, and those are compensable injuries.
Which raises this issue. There's a place at Camp Lejeune called Baby Heaven, where all the infants who died, there were so many infants dying because they were drinking benzene instead of milk, that they have a large cemetery there called Baby Heaven, and I understand it filled up and they had to put in a second Baby Heaven. So it's sad. You can imagine
what a betrayal.
You can imagine the mother drinks the water, is exposed to the water constantly while she's pregnant, and then the baby's born in a weakened condition, and then to top it off, the baby is bathed in water and gets a kind of exposure to water itself. That's why you end up with a cemetery called Baby Heaven.
Wow. Okay,
Camp Lejeune.
Let's talk about the insufficient medical studies and below equipoise. So what happens if a plaintiff has one of those diseases? Let's talk a little.
Okay, so if you're below equipoise, you don't get a presumption. You don't have presumptive causation. And for example, in breast cancer, there's no presumptive causation. Breast cancer is caused by PCE, TCE, DCE, and vinyl chloride. Now, interestingly enough, the male breast cancer is very close to becoming presumptive because of the studies. Esophageal cancer is caused by TCE and PCE. Now, it doesn't mean that you can't recover for it. It just simply means you don't get the presumption You don't get presumptive causation. You bring in your epidemiologist and your own expert witness, like pancreatic cancer, for example. You bring in a pancreatic specialist, you prove up the exposure to benzene. There's studies showing that benzene causes pancreatic cancer. The reason they're below equipoise is not that they're not caused by these substances. It's because there are not enough studies. You don't have the studies, you don't have the medical, scientific studies, epidemiological studies to support the proposition that benzene causes pancreatic cancer. But that doesn't keep you from getting your own epidemiologist and have your own epidemiologist do studies himself or do research and come in and testify, and then get an expert witness on pancreatic cancer and have them testify just like you would in any lawsuit, and create your own, meet your standard that way. So don't give up on these just because they're not presumptive causation. Any cancer, when you have this many carcinogenics for a period of 34 years, any cancer is worth looking at in terms of being caused by all the various things that were on this base. So you just may need, what we might do is we have several attorneys who are going to have an awful lot of cases. So what we might do is take something like brain CNS cancer. And we might take, if we have enough cases between us, we might pool our cases. You might have, let's say you have 50 cases between you, then we might go do our own study. We got a couple of years to get there. We may do our own study to make those cases, to get the sufficient proof to get those cases up to equipoise. But if not, at least sufficient proof to get evidence from an epidemiologist and a doctor as to the cancer in that case. And that's entirely possible.
So that's the big point. The big point is, even if it's not equipoise or above, those cases are still can be very meritorious. So.
Right. The other, they did in 2012, in Obama's administration, they did pass a Camp Lejeune Families Act. And this was not for what we're doing here. This was not for a third-party action. This was to get veterans benefits. And this is interesting evidence. They have a list of the cancers and other injuries that they did their own study, and they determined that these were sufficient to get treatment, to qualify for treatment at the Veterans Administration. So those are breast cancer, esophageal cancer, female infertility, hepatic steatosis, kidney cancer, leukemia, lung cancer, miscarriage, multiple myeloma, myelodysplastic syndromes, neurobehavioral effects, non-Hodgkin lymphoma, renal toxicity, and scleroderma. A lot of those are the same as the ones that are presumptive causation, but some of those are not. I don't think we will get presumptive causation on this. We might, but I don't think we will right offhand, because this was a study. This study was done to see if they qualify for Veterans Administration benefits and treatment. It's not a study to see if they qualify for, as more likely than not, or equipoise or whatever. So it's a different standard that these are brought in under, but most of them are the same anyway. But that's something that's it's evidentiary that the Veterans Administration did acknowledge them. And you could always submit it to the court to see if you can get a presumptive causation based on that. Right. There are other conditions that are pretty substantial, but at this point, there's not enough information, not enough scientific information to meet the standard, and that's there are major fetal malformations, cervical cancer, colorectal cancer, ovarian cancer, Hodgkin's disease, and the fact is most any cancer, soft tissue injury soft tissue sarcoma doesn't sound like much. The soft tissue cancer, wrong. Soft tissue sarcoma is deadly, and it's very complicated. Spinal cancer, intestinal cancer, gallbladder cancer, thyroid cancer. These are all potential. The fact that you can't pursue a claim under presumptive causation does not mean that you can't prevail on those cases.
Okay, I mean, so that's a lot of information that we've covered in this last hour. It was supposed to be a little less than that, but is there any other messages you want to leave to?
There's one more clue I saved till last because it's the biggest mistake you can make.
All right, let's hear it.
When you file your claim, your 2675 claim, the administrative claim, you are required to put down a sum certain as your demand. And they'll ask you, and they won't accept the claim if you don't have a sum certain on it. So if you say, okay, it doesn't matter, you put down $10,000. And because I'm not going to settle this thing at this level anyway, so then you go on into court, you try a case to a jury, and they give you $500,000, you've recovered $10,000. Because the amount you put, if you don't remember anything else I say today, the amount you put as your sum certain that you're demanding at the administrative level is the most you can receive at the trial level, unless you can show new evidence of information, for example, cancer that was not known at the time you handled the first one. So that's a deadly potential pitfall for plaintiffs' lawyers.
Estimate in excess of the high side, far in excess of the high side, I guess. Yep. Just imagine you're asking for money in closing argument, and what's the amount you would ask for, and then double or triple that perhaps.
Yeah.
Okay. Any other points want to leave the audience with?
One last point in signing up cases, getting cases. Always ask your client about the other family members that were exposed. Always ask your client, was your wife, did you live in the residential housing? Did you have children when you were on the base? And we found that we have clients where we'll sign up one client and then we'll end up with 6 because they say, yeah, well, my mother and father were both at Camp Lejeune, and then my brother and I were both Marines, and we were at Camp Lejeune, and then my grandfather, and this was an actual case, and so, oh, by the way, yeah, my grandfather, I forgot about him. He was a Marine. He was a career Marine. And I said, okay, I need to talk to him. Well, he's in the hospital right now because he's dying from leukemia. So we end up with 5 different independent claimants with 5 different cases of different kinds of cancer off one conversation with one plaintiff.
Wow.
So always one of the best sources of business is your own clientele.
What an excellent point.
And you can also ask them if they know any of their friends that they served with at Camp Lejeune who are having the same kind of problems now.
What an excellent point. Okay. Well, I guess until next time, I appreciate it.
Until next time, sir.
All right. It's good seeing you, Howard. Have a nice
day. See you, David. Thank you.
Buddy.